Hey, ladies and gentlemen. I'm just gonna do a lecture this way. I was thinking I could probably Zoom it, but I can't predict how I'll feel tomorrow, so I'm just gonna record the lecture for Tuesday, and you guys will have the ability to take notes as you are shared with this video. So, the last thing we did was we were talking about the presidency. Article 1, legislative, Article 2, Article 2, executive, and now we're on Article 3. Um, Couple things I want to go through. First, you guys need to remember that the Supreme Court is the only court mentioned in the Constitution. That is the only part of the judicial branch that the framers had in mind. Okay, they thought many of the issues that could be brought up in a court situation were going to happen in the states. So at that point, they didn't really believe that there was any need to have anything more. And then they included in the Constitution that tribunals, lower courts, Congress had the ability to create. So if when we look at our district courts and we look at our appellate system, they were created by Congress as the nation grew and the needs and the disputes grew. So Congress created more court systems. In the Constitution, it talks about the jurisdiction. Jurisdiction in the judicial sense is saying that um, a certain court can hear certain kinds of cases. And the two types that I'm going to ask you to know are original jurisdiction and appellate jurisdiction. So we'll start with original. If a court has original jurisdiction over a case, it means it's hearing it for the first time. So most often what we're seeing in that is the trial court. And at the federal level, that would be the U.S. district courts. So these are the cases where there's if it's a criminal case, the prosecution is the U.S. government, and then there is a defendant. And so they would go, and this would be with the jury and the evidence and the cross-examination, deliberation, and a verdict. Okay. Once a trial court has completed its responsibility, it then becomes part of the defendant or the person who lost to appeal the case. And if a case is appealed, it then goes to the appellate. So just to remind you, appeal is asking a higher court. I'm going to just highlight appeal here. Appeal is asking a higher court to review the decision or the procedure of the original jurisdiction court. And I think sometimes people just think people are just gonna appeal their cases because they don't like the verdict. The appeal always has to be on constitutional grounds. You don't appeal because you think you got too many years. You appeal because you believe your sentence is an excessive fine under the 8th Amendment. So, again, these are the things we're finding in Article 3, and I probably should have mentioned that right away, that we are looking at Article 3. All right, moving on. Unlike the House, the Senate, and the presidency, the requirements for a member of the federal judiciary is very different. Constitution mentions No requirements for age, residency, or citizenship. So because of that, it is possible that we could have a federal judge who isn't even a U.S. citizen. It's not going to happen because nobody in Congress is going to agree to that, but the Constitution never did specify. The big thing I really want to make sure you guys get out of this is that a term for a federal judge is good behavior. Now, this is one of those points where I really thought the framers were incredibly brilliant in how they made this decision. Okay? We always consider federal judges in office for life. That is true. But if you look up here, if this is the Constitution and Constitution sits on the top, anything below it has a responsibility to follow the law. However, if the framers had used the term life, that would have put justices outside the responsibility of the Constitution. So this was actually a very good decision on their part. Now, they can be removed as well. Judges can be removed. They can be impeached. What we're watching at the court right now is questions over ethics and gifts being given to justices. There's a big controversy right now with Clarence Thomas and how he accepted some very lavish gifts from an individual who says he didn't have any requests for Clarence Thomas or expectations in judicial decisions, but now more is coming out that they're now starting to question that. And because within the Supreme Court, they have the ability to make their own ethics boundaries, John Roberts is saying everything's good. All right. Another thing we find in Article 3 is that judges' compensation can't go down. Framers knew that judges would be holding a position in the federal judiciary for years. And so it's not their decision to increase compensation. It is Congress's job to increase compensation for the federal judges. The only thing it does stipulate, though, is that it cannot go down, because we cannot punish a judge for a decision that society may not have liked. Makes sense. I mean, I think there would be serious questions over the Dobbs decision if these justices should have their compensation go down, because society wasn't exactly excited about that. Now, and the last thing is in Article 3 is the definition of treason. Now, treason is really it is one of the highest crimes against the country. It's basically denied as giving aid and comfort to an enemy, helping an enemy gain momentum against the United States, or get information that would put American security in harm's way. And in order to be convicted for treason, which is an incredibly crazy process, there have to be 2 witnesses of it. So I'm going to ask the sub if she will show the video that goes with this section. This is a video of a young man who is an American citizen who, prior to 9/11, went and joined, I don't remember if it was Al-Qaeda or Taliban, and U.S. forces found him in a group fighting against Americans, and they took him into custody. So I'm going to pause this, and then I will come back once that video is done. Okay, so an example of the reason he wasn't with treason wasn't charged with treason, which could carry with it the death penalty, is that um I'm losing my train of thought here. He joined the Taliban prior to 9/11. He's even been interviewed where he has said he was in the room with Osama bin Laden at one point. But even though he was fighting with the Taliban and then fighting against Americans, they said it can't be treason because he didn't join as a result of 9/11. He joined prior to 9/11 without any knowledge that 9/11 was going to happen. Sounds like a little technicality, but that's what they're looking at. All right, so next one is I'm going to go from the bottom up. And I know we've kind of talked about these, but I just want to make sure we go through. As you can see, the federal district court is broken into 3 levels. So I'm going to start at the bottom. At the very base of our judicial system at the federal level are the U.S. district courts. These are the trial courts. Somebody breaks a federal law, they will, my apologies for that break. I just wanted to pull up some pictures for you to see the federal courthouse in Minnesota. So this is located in Minneapolis. And this is where federal cases are heard in Minnesota. Because if we remember in looking at, and I don't know if I can pull up any more pictures that'll give you an idea. What's interesting is this is Minneapolis City Hall. This is the old building that looks like something out of Harry Potter. And so the federal courthouse is right across the street. And it's not even a street. Well, there is a street right there, but it's across directly on the next side of the street in Minneapolis. So, and so there's 94 of these scattered out through around the United States. And the unique thing about the U.S. district courts is that they are always original jurisdiction. They are always the court that hears the case in its first appearance, its original state, where the attorneys will come in, they will present the witness and evidence, they will have a jury, the jury will deliberate, they will come back with a verdict. That is what all of this is done in the U.S. District Court. Now, if there's a constitutional question, and I'm a defendant, I've been found guilty, but I don't believe that I had been given my constitutional rights to have my lawyers present evidence that would benefit me, I have a constitutional concern. So now I can appeal, ask a higher court to review my case, and I can appeal to the U.S. Court of Appeals. Now, we've talked a little bit about this and how the United States is broken up into what we refer to as circuits. So they've taken a number of states and put them together and said these states are part of, in our case, the 8th Judicial Circuit. So if I appeal my case, I could possibly have my appeal heard in Minneapolis, but it's probably more likely that I would end up down in Kansas City with the 8th Circuit Court of Appeals taking place there. So it is possible that case can be appealed. In a court of appeals, you're not talking to one judge, you're talking to 3. And these 3 judges are really trying to decide. Let me get that down a little bit. That's pretty. was, were constitutional rights violated? That's really what they're there to answer that question. We're not going back through and having all the witnesses come back. We're not showing all the evidence. There's no jury. We're asking these three judges, based on the appeal, was there a constitutional violation issue? Now, if they make a decision and they say, no, there was not, that could be the end of it. But if they come back and say, yes, there was, they have the ability to say, change this and redo the case at the district level. And then, of course, the one we've talked about most is the Supreme Court. Most of the time, the Supreme Court is an appellate jurisdiction. It is more than obvious that the Court of Appeals is appellate because it's just in their name, the Court of Appeals. The Supreme Court, there are some rare conditions where the Supreme Court may hear a case first. Cases like what we've seen in the last couple of years. Did Donald Trump have the ability to exercise executive privilege when the January 6th commission in the House of Representatives was subpoenaing members of his staff to come in and testify? And so he would say, that's my constitutional protection. Well, there's no reason to have a case here, so it honestly went right to the Supreme Court and they would answer the decision. Now, over here, I want to go through this carefully. There are only two ways in which a Supreme Court decision can be changed. So, 1973 Roe v. Wade. Then we go to 2022, the Dobbs decision. The Dobbs decision is the law. And that is what the Supreme Court has determined. So if we were ever to take it to the federal level again and ask the federal government to reinstate that a woman's right to choose reproductive issues is within her right, not within the states, they would need to go to the Supreme Court again, possibly starting at a state level and working its way all the way up through the process. So how do we change a Supreme Court decision? Well, the first one's here, that a future court changes the decision. And that's what we saw with Roe v. Wade. Roe v. Wade was the law of the land until the 2022 court came in and took on the Dobbs case and came back and said this should never have been given acknowledgement at the federal level. This is indeed a state issue. So we saw that firsthand. Or another way to change a Supreme Court decision is through a constitutional amendment. Dred Scott, 1854, he was a slave and his owner moved north to free territory. So Dred Scott believed he must be free because he's been moved into a territory that doesn't even acknowledge slavery. And so he challenged this, thinking he was a free man. And this case is always so interesting to me because I'm really surprised he was even given the ability to have a case that went all the way to the Supreme Court. So the Supreme Court gets his case, and they make a decision that slaves are property, and no matter where the slave owner moves, he has the right to take his property with him and use the property as it's meant to be used. So Dred Scott loses his case. He is a slave for life, not just when he's in the South. So how do we change that one? Well, we go to 1865. My computer doesn't like me. 1865 with the 13th Amendment, which abolishes slavery. So they make a decision that Dred Scott is property forever. The court comes a few years later and says slavery is illegal, freeing all the slaves, which is the way they overturn the Dred Scott decision. I hope this makes sense. If there's something that's not making sense on these two slides that I've covered, I really do want you to write down questions so that I can answer them when I return. So, a couple other things I wanted to touch base with. Here's your current fort. Here is our current fort. And they are in order of seniority on this picture. Okay, so I'm going to have you write the names down as I go through these. And let me get a color that's going to stand out so you guys can see it on their black robes. This is John Roberts, Chief Justice of the Supreme Court, and he was appointed by, I probably need to put this a little higher. He was appointed by George W. Bush, okay, in 2005. He actually replaced the previous Chief Justice. He was not part of the Supreme Court and got a promotion. He was actually nominated by Bush to literally go into the vacant Chief Justice position. So every court goes by the last name of the Chief Justice. So we are in the Roberts Court right now. The Roberts Court is not looking good. There's issues with how it's being run, how they're not getting along in the Supreme Court, and that the popularity or satisfaction of the Supreme Court is probably lower than anything I've ever seen. So it's pretty incredible that the Supreme Court has lost so much respect. All right, our next person who is on the court the longest is Clarence Thomas. Now, he was put on the court by George H.W. Bush, George Bush's father. He has been on the court since 1991. I was in, oh golly, junior year in college. I was in a sociology class with and there's no other way to explain her, an over-the-top feminist. And during Clarence Thomas's confirmation, this woman by the name of Anita Hill came forward, who had worked with Clarence Thomas in some of the judicial work he had done before becoming a justice on the Supreme Court. And she accused him of sexual assault. And I will remember that day in class because overnight they said they were going to bring her in, and the day of that confirmation hearing, our professor comes into the classroom and she says, everybody needs to leave right now. Everybody needs to go. And I thought there was an emergency. Well, there wasn't an emergency. She was demanding that we went and watched the confirmation hearings of Clarence Thomas because it was getting very animated and very, it was a big deal, big scandal. 1991, that really wasn't tolerated. Amazing where we're at today. All right, our next one, let me make sure I've got the right color on. This is Sam Alito. He has wanted to retire for quite some time. And we'll talk about that here in a second. He was appointed by George W. Okay, so he is another one of George W.'s appointees, um, January 31st, 2006. So Bush's term went from, God, I have to go back. January, he took office in January of 2001 and ended in January of 2009. So during his term, he was able to get 2 justices nominated. So the next president that has some legacy on the court is Barack Obama, and this is, yep, I knew I was going to do this, it wasn't going to work, right? This is Sonia Sotomayor, and she is an Obama nominee. And she is the first Hispanic woman to sit on the High Court. And it does. Backgrounds, demographic differences, age, gender, upbringing, that's all going to play a role in how they look at the laws. So knowing some of these specifics is important. Obama had a second nominee, oh dang it, by the name of Elena Kagan. No, I'm really struggling. Or the computer hates me. Okay, we're just going to move this up. And again, I'm not going to get it in there, but she is also an Obama nominee. So on the current court, we have one from George H.W. Bush, two from George W. Bush, two from Obama, and three of them from Donald Trump. So Donald Trump, his start following the death of Antonin Scalia, this is the one where Scalia passed away in February of 2008. And based on that, no, I lie, it wasn't February 2008, it was February of 2012. It's coming to the end of Obama's term. Well, Obama, having 11 months left, appoints a judge to the Supreme Court by the name of Merrick Garland. The Senate, who was controlled by the Republicans, said we will not even entertain the nomination from President Obama. And so it was ugly, and the Senate was like, the incoming president should have that ability, not an outgoing president. So, and I'm going to see if I can find it. Hold on one second. All right, I think a timeline will help explain this a little bit better. So I'm just going to flip to this. You don't have to write this timeline down. I think it's just important for you to hear what took place. All right, so in February of 2016, the most conservative justice on the Supreme Court passes away, Antonin Scalia. Unexpectedly, crazy thing. So it was February 13th, 2016. A month and 3 days later, Obama nominates Merrick Garland to fill Scalia's position. Now, Scalia was very conservative. Merrick Garland was not. He was more of a moderate, left-leaning liberal than he was not a conservative. Well, the Senate held the majority at that point, and so the Senate under Mitch McConnell refuses to even consider Obama's nomination. Their argument was that Obama isn't coming back to office. He is at the end of his 8 years, and we aren't entertaining a justice from Obama because we know he's going to be liberal and it's going to affect the court. So literally um, almost 11 months later. So we've got an 11-month streak here where we only had 8 justices on the court because Obama's nomination, they wouldn't even visit with him. They wouldn't even talk to him about, they weren't going to do it. They just refused it. So then on Tuesday, November 8th, it's the general election and Trump wins. So Trump takes office at noon on January 20th. 11 days later, he nominates Neil Gorsuch, who is a conservative justice. Okay? So in this time, Lindsey Graham, who's a senator from South Carolina, has stated a president who is not returning to office should not have a say in Supreme Court positions. And he said, if we get to the 2020 election and we have something similar to this, you can use my words against me that we shouldn't allow an outgoing president the ability to nominate a replacement. Well, it was kind of crazy because on September 18th, Ruth Bader Ginsburg dies. So we're talking, so Scalia died in February, March, April, May, June, July, August, September, October, November. It was 9 months to the election, and the Senate wouldn't even acknowledge Merrick Garland. In days, Trump nominates Amy Coney Barrett. The general election takes place November 3rd, 2020, and he loses the election, which is how we got 3 judges on the Supreme Court from Trump. So let's just go through those 3 to make sure everybody's got their names. So we have Neil Gorsuch, Brett Kavanaugh, and here's Amy Coney. Oh, not a big one. Barrett. Okay, so those 3 are all Trump nominees. This one is because the Senate wouldn't fill that position with Merrick Garland. Brett Kavanaugh came on because of a retirement of Anthony Kennedy, and Amy Coney Barrett, who is very conservative, took the place of a very liberal judge, Ruth Bader Ginsburg. And so we have one new. This is Ketanji Brown Jackson, and she was nominated by President Biden. So we do have a full court right now, but if we look at it, we're looking at 1, 2, 3, 4, 5, 6 conservative justices versus the 3 more liberal. So a lot has changed. And remember, if they're sitting with a basic life tenure, it's crazy because George H.W. Bush is been deceased for a long time, and he still is influencing American policy because he still has Clarence Thomas on the court. All right. If you have questions on this, please make sure you ask. All right, so here's the formal photo. Every year they do a formal photo. And it's always in seniority. So Chief Justice John Roberts sits in the middle. To his right is Clarence Thomas. He's the most senior. Then they alternate to the next most senior, which is Sam Alito, and it goes back and forth. Sonia Sotomayor, and then Elena Kagan. Then behind the Chief Justice, so we got 1, 2, 3, 4, 5. 6th is Gorsuch. 7th is Kavanaugh, 8 is Coney Barrett, and the ninth and newest member um, is Ketanji Brown Jackson. So when a new judge joins the court, these get switched up. So if Sam Alito decides to retire, and he's not going to retire with a Democratic president, he won't do it. Because he in a Democrat controlled Senate, because he is adamant that he does not want the court to go back to a liberal base. So I think on that note, I think that's plenty for today. Tomorrow I will continue on with this, and we'll be looking at some articles on the court. So, um, yeah, if you have questions, make sure you write them down. Otherwise, and then I can cover them when I come back. Otherwise, we will continue. Thanks, guys. Thanks for being patient with me.